In this presentation, we will discuss consumer protection. At the end of this presentation, we will be able to describe social engineering, explain the concept of public interest, describe the conditions for negligence, explain Consumer Protection Safety Act, discuss the Federal Trade Commission Act, list unfair business practices, and explain the Truth in Lending Act. One large component of consumer law has to do with product liability. And under product liability, if there are unsafe conditions that harm a person, that individual could recover damages from the manufacturer, the seller, or supplier of that product that had that condition which was unsafe. When considering the application of product liability law, we have to consider what the reason for the law will be, and in order to do so, we want to consider the concepts of public interest and public policy. Public interest is going to be the concept that there is some goal that we would like to have within the public which would be better for the public. So we have some ideal goal that would be in the public interest. Actually implementing then a policy that would then enforce that goal would be the policy that would lead towards that particular goal, that particular public interest. When law is going to be used in order to facilitate some type of public good, for example, if there's some consensus that it would be beneficial for the public in general to reduce something like pollution, we may implement some type of regulations, some type of laws to regulate the emissions, such as car emissions. We might have some carpool type laws in order to be put in place. And those laws then would be the public policy that would be put in place in order to achieve the specific goal that would be the public interest. We can term this idea of structuring the public policy as a form of social engineering. We're putting in systems in place in order to achieve social goals for the majority of individuals, hopefully the majority of individuals agreeing upon the public interest of those social goals, that social engineering then being a process for us to get to those public interests and social goals. The Federal Trade Commission helps to regulate and shape laws with relation to commerce and trade, and this will be an example of social engineering. This ability for the Federal Trade Commission to be able to regulate and shape the laws and regulations with relation to commerce gives them a lot of power within this capacity, the power to basically create laws and to judge the laws in this particular domain of commerce. When considering the type of social engineering goal applied to consumer goods, we of course want a public goal of having healthy public and avoiding illness and injury, and that would lead us to want to set up laws that would safeguard individuals and consumers from buying products, especially unwilling or unknowingly, that would be harmful or could injure individuals. How could we achieve these goals? Through social engineering. We can find some way to hold the sellers and the manufacturers of these goods responsible for any damages or injuries resulting from them. One concept applicable to product liability is the concept of negligence. In order to prove negligence, an injured party would have to say that or prove that the manufacturer or seller had some type of duty to the victim. Then the manufacturer or seller violated that duty by not following the appropriate kind of care that should be given, and therefore is in some way negligible of the duty that should have been cared for, that the victim had some kind of injury or suffered some kind of problem due to the lack of care, and of course prove that the injury was due to the lack of care and due to, in that case, negligence. The concept of negligence can be contrasted to the concept of strict liability with regard to the product liability. Under strict liability, the manufacturer is going to be held responsible for an unsafe product regardless of whether there's fault or negligence. The focus here not on the conduct of the manufacturer, but on the safety of the product. We're focusing here not on the duty that was neglected in terms of the manufacturing necessarily. We're focusing more on the product itself and whether or not it in itself is a safe product. In many ways, this comes down to the design of the product. We have a duty of design within the product to make sure that the product is designed in such a way that it is safe or meets some type of standards for public good, for public interest. We also want to see that we have some type of instructions so that the users could have the information necessary in order to use the product in a safe way, as well as warnings if there are any problems with the product that need to be particularly aware of. Should be something that the consumer would be readily and easily aware of. In order for a victim to win a strict liability case for product liability, they would have to prove a few different things, including that the seller or manufacturer sold the product in a defective condition. So at the point of sale, there was a defective condition within the product at that time. The seller or manufacturer engaged in the business of selling the product, so we have to prove that there was a sales transaction happening for the product. The product was unsafe to an unreasonable degree to the user. So the consumer or the user has ability to prove that it was unsafe to some type of degree. What is that degree? That's of course going to be a word that's not as easy to define, and we'd have to prove that or define that within the process. The defective condition was the proximate cause for the injury or damage, so we're got to prove that this problem with the product is the reason for the injury to the party involved making the claim. The defective condition exists at the time it left the manufacturer. So we can't say that there's some type of condition that happened after that point in time. We typically have to say, well, this is how it was at the point of sale, and that condition that was there at the point of sale is what led to the eventual problem. The consumer sustained physical harm or property damage. So we have to actually prove or show what the harm was resulting from this situation from the defective product. A Consumer Product Safety Commission, the Cpsc, was created by the Consumer Product Safety Act to protect consumers from unreasonable risk or injury from hazardous products. The Consumer Product Safety Commission has the power to force a recall of products that are considered to be unsafe or dangerous. Consumer protection laws are laws that are applicable between a business or business person and a consumer. So when we have a law that a consumer purchased something from a business, then that would be applicable under the consumer protection law. This includes consumers who lease or buy real estate, goods, or services for the personal, family, or household. So the end use then being the personal consumption for the personal household, the purchase being from some type of company or business. The Federal Trade Commission Act, or FTCA, helps to regulate unfair or deceptive practices between states. So interstate commerce is thought to need added regulation to be able to regulate practices from state to state. If there are practices or business practices that are taking place that go into different state or across state lines, then the FTCA could be applicable to them. If we're talking about practices, on the other hand, that are all within a particular state, intrastate commerce, then the FTCA may not be applicable to that. And again, the idea there is basically that we want some sovereignty. We want sovereignty between the states to be able to regulate their own laws, including commerce. But when the commerce goes from state to state, we want to have some type of uniformity between the states so that we can facilitate commerce between states. And that needs some added regulations, and part of that would be the Federal Trade Commission Act. The Federal Trade Commission Act has the ability or has given the authority to the Federal Trade Commission, some of those being and including the ability to look into antitrust violations. Those are going to be antitrust violations that have to do really with monopolies and typically the behaviors that monopolies may take, which would be non-competitive or unfair type of acts from monopolies. They also have the ability to investigate practices of businesses that fall into their jurisdiction, typically businesses that have commerce that would be interstate commerce across state lines. They can publish the results of their investigations for the businesses, and they can also make recommendations to Congress about some new legislation based on the information that they have gathered through these powers that they have. Clearly, the FTC has a lot of authority in order to influence businesses that go across interstate commerce, and need to be careful then of how they're going to apply this authority and how they're going to be able to enforce the authority. One way, if the FTC finds some type of violation with a company, is to try to find and have the company be in compliance voluntarily with the decisions of the FTC. So they could request a consent order, and the consent order would basically say that the business would agree voluntarily to stop the business practice that is in question without having to say or admit that any violation of law was put in place prior to that. And that's going to be kind of a softer way that the FTC can then go in and influence the system without causing too much trouble, and be able to put pressure on companies in order to make changes without going through the long drawn-out legal battle, which has a lot of repercussions on both the business itself and everybody involved in terms of commerce as well. If a consent order does not remedy the situation, then the FTC may issue a complaint, and the complaint would have a more formal process with an administrative law judge. And if a violation is then found, it could issue a cease and desist order to the company to stop the practice. Consumers may also put together class action lawsuits against the business for violating the rules of the FTC. And the class action lawsuits are going to be a type of tool that can be applicable to put pressure on businesses as well, because the liability that could be caused oftentimes to an individual may be small enough that they would not want to go through the legal process, and because the cost would be higher than the benefits they may get from it. However, if we pool all the harmed parties together and represent them as a whole in a type of class action lawsuit, that's a way that pressure can be put on companies that are not in compliance with what we would think would be a social justice type of case, or taking their due care in terms of the types of products they're having. That would be one tool that can be put together. It's also, of course, as we've seen before, that tool can be considered to be abusive in some cases. It's possible to abuse that type of tool, because when we are in a class action lawsuit, the majority of people that are involved in it only really have potential gain if they win the lawsuit, and have no potential loss if it's not one, because they're not really the one that's paying for the legislation. So we do have to be careful of the application of the class action lawsuits, but it can be another tool in order to implement some type of pressure, social engineering type of pressure, to get businesses to comply and have a duty of care. One deceptive practice that is prohibited by the FTC is the practice of fraudulent representation. And fraudulent representation, as we know, fraud is going to be some type of deception in order to have a personal gain. So there's basically some type of lie or misrepresentation, or possibly even not presenting some relevant fact could possibly be a component. But usually we're talking about misrepresentation. If we're talking about the selling of goods, we're typically talking about the misrepresentation of the goods that we're selling, saying it's of a higher quality, or saying it meets some type of standards when it in actuality does not. Some other common forms of unfair or deceptive practices would be something like an unordered merchandise. If we were to actually ship merchandise to individuals that did not order them and bill them for that unordered merchandise, that would be something that would be a fraudulent act. And if we intentionally did that, of course, we did that with an intent to deceive. A common form of fraud or a common form of deception is a bait and switch type of act, in which we give a very strong or very nice incentive for a particular product in order to draw someone in to a discussion with us, or hopefully possibly into a store where we have no actual intention. That's where the fraud comes in. That's where the lie is. In essence, we have no intention of actually selling the good that was advertised, but rather get someone into a sales position so that we can then sell them on some other item. Those are just going to be some common type of basically deceitful type of practices that could be in place, and which are considered to be unfair and therefore would be a violation. Two cyber laws are the FTC's Children's Online Privacy Protection Rule and the Identity Theft and Reclaim Your Name proposal. These are both going to be dealing with the idea of identity. When we are online and we're doing business transactions online, one of the major problems has to do with identity. The revised Children's Online Privacy Protection Rule has to do with businesses who have online customers who are children particularly under the age of 12, who would be giving data, personal data, to the company, which of course is a common practice when we have the social interaction in terms of many of the online practices. And therefore, in order to have more protection on children, particularly the children under the age of 12 under this regulation, then there's going to be a requirement if we know that our target audience, or if the business knows that the target audience is children under 12, they need to have a requirement in order to have the consent of the parents in order to retrieve any personal data. The Reclaim Your Name program is an attempt to try to restrict the ability to steal a personal identity, and obviously online, one of the biggest problems, a big problem of online transactions is the attempt to steal personal identities and then use that for whatever purpose there may be, whether that be for actual theft in terms of financial data or some type of spamming use or whatever that use may be. And the Reclaim Your Name is going to be an attempt in order to help consumers to be able to identify and monitor the use of their personal data, which is online. The goal being the ability to empower individuals over their personal data and therefore be able to regulate the information that is out there and lessen the ability for people to abuse identity theft and the anonymity that is part of the process of online processing and working with online and business transactions. Because of the ease of financial transactions and the use of things like credit cards, lending becomes very important for most individuals as well. We use often credit cards in particular in daily transactions, and we do compare many times one credit card service to another, the banking services and the lending services, but it's possible for that to be a bit unclear for the average user, considering it's kind of just part of the daily practice. We may not be able to put as much time into looking into these things as we should in order to get our best results from them. In order to deal with it, the Federal Truth in Lending Act is in place, and that's to try to give information to the consumers so they can make appropriate comparisons. And that has to do with making sure that the banks are giving the appropriate amount and disclosing what the finance charges are, as well as the percentage rates or the APR rates, so that businesses and consumers can then make an easy comparison when they're considering these practices, these lending practices, and they can do it quickly, because typically we want to do things quickly these days. We not want to be able to make a quick comparison. What are the finance charges from this card to that card, or this bank to that bank, and what is the APR rate? The Equal Credit Opportunity Act makes it illegal for banks and businesses to discriminate against credit applicants because of their sex, race, marital status, national origin, religion, or age, or because they get public assistance income. The Truth in Lending Act also makes it so that the credit card owner is not responsible for any charges made after the card issuer has notified the loss or theft or possible unauthorized use of the card to the issuer of the card. So once the claim has been made, hey, the card has been stolen, there's been a loss or the theft, any purchases from that point forward under the Truth in Lending Act should not be applicable to the cardholder. Obviously, the Fair Credit Reporting Act allows for some more transparency for the consumer to know what is in the credit reporting. So the consumer basically has the right to know all the information, in essence, all the information that is in his or her file. The consumer also has the right to know the source of the information that is in the file. So there's going to be some transparency so that the consumer knows what is in the credit reporting, and then can basically follow up on that and know who is responsible for the source of the information in the credit reports. Under the Fair Debt Collection Practices Act, there's going to be specific rules that must be followed by companies that are in the business of collecting debts from others. These are going to include things like, if we're going to try to collect the debt from an individual, we are locating the individual. We can't really tell other individuals that consumer owes money to them as part of our research process. We also, if someone is being represented by an attorney, we know they have an agent, then we need to go to that agent in order to go through our collection process. We generally need to be respectful of the time constraints of when we go through the collection process in terms of the time of day and the appropriate times and places in the week. The debt collection action should not take place at the consumer's place of employment. We should take the debt collection action or pursue it at a time other than the place of employment. The debt collector should not be talking to another individual about the debt collection. Should only be discussing the issue of debt collection with the individual who is they're trying to collect debt from. These are just a few of examples of types of practices under the Fair Debt Collection Practices. For more accounting information and accounting courses, visit our website at accountinginstruction.info.